You're watching The Commander. All right, Albert. The question I've been asked the most since Donald Trump's conviction is whether the Supreme Court can eventually overturn this conviction from New York. Can you walk us through the appeals process and explain where this case will go within the court system?
That's a good question, but let's cut to the chase and not bury the lead. The Supreme Court can do whatever it chooses, as we've seen. However, there are a lot of caveats to consider. This is a state case, not a federal one. Typically, federal courts don't play a role in state cases since states are their own sovereign entities, separate from the federal government. They run their own judiciary and criminal justice systems independently. In the vast majority of state court prosecutions across all 50 states, cases go through the state court system, usually with two levels of appeal, an intermediate appeals court and a state Supreme Court. When a state Supreme Court upholds a conviction, that's typically the end of the road. This is true for about 99.5% of cases. This particular case is a New York State court prosecution and conviction, so it will take some time to work its way through the state appeals system. However, there are instances where a state court case can jump into the federal court system. How does this happen? Let's use a concrete example. The litigation in Colorado where Donald Trump was disqualified from being on the presidential ballot. After a state court judge found that Trump engaged in insurrection on January 6th, the case went through the Colorado State Appeals Court system and was affirmed by the Colorado Supreme Court. You'd think that would be the end, right? Not quite. Trump managed to get the Supreme Court to take the case for review. So here's what people need to keep in mind. Once a state court case has run its course through the state's appeals court, the defendant can ask the Supreme Court to take their case. The Supreme Court rarely agrees to these requests, but if there is an issue of exceptional constitutional importance, specifically federal constitutional importance, they might. If they believe there's a significant question regarding a violation of federal constitutional rights by the state courts, the Supreme Court can step in. That said, I don't see any legitimate reason, legal, constitutional, factual, or otherwise, for the Supreme Court to accept this case for review. However, with Justices A.O. Thomas, Roberts, and Gorsuch, who knows what they might do?
And could the Supreme Court take up this case simply because they find an issue with, for instance, the sentencing? Let's consider a scenario where Donald Trump is sentenced to a prison term. Could the Supreme Court then decide to step in solely to prevent him from being incarcerated? Would they have the authority to review the case on the grounds of sentencing issues, even if it's a state-level matter? Is there a precedent or legal framework that would allow them to do so, particularly if they believe there's a significant constitutional question at stake? How does this process work, and what are the possible implications for the judicial system?
I must start by emphasizing that the Supreme Court has demonstrated it can act with a high degree of autonomy, making decisions that sometimes appear inconsistent with a strict interpretation of the law or the Constitution. This is a troubling reality for someone like me, who has spent his career striving to ensure that our legal system remains faithful to constitutional principles. Now, to address your question regarding sentencing and the potential for the Supreme Court to take up this case, it's a complex issue. The Supreme Court, in general, does not have the authority to review state court decisions unless there is a significant federal constitutional question at stake. They cannot simply take up a case because they might disagree with the sentence imposed by a state judge on a subjective basis. For the Supreme Court to intervene in a sentencing matter, there would need to be a compelling federal constitutional issue. This typically involves a situation where the sentence imposed is illegal. An illegal sentence would be one that exceeds the statutory limits or is imposed in a manner that violates fundamental constitutional rights. For instance, if Judge Merchan were to impose a sentence on Donald Trump that is beyond what New York law permits, or in a manner that is arbitrary and capricious, then there could be grounds for a federal constitutional challenge. However, this is highly unlikely. Judge Merchan is known for being a seasoned and judicious legal professional. He will undoubtedly impose a sentence that is not only appropriate and just, but also firmly within the legal boundaries established by New York state law. His decision will be based on legal precedents, statutory guidelines, and the specific facts of the case, ensuring that it withstands scrutiny. Moreover, the process for a state case to reach the Supreme Court involves several layers of appeal within the state court system first. Donald Trump's legal team would have to exhaust all state-level appeals before petitioning the Supreme Court to take up the case. This is a long and rigorous process, and the Supreme Court accepts only a tiny fraction of the cases presented to it. In conclusion, while the Supreme Court has significant power, it is bound by procedural and substantive limitations when it comes to state cases. Unless there is a clear and pressing federal constitutional issue with the sentencing of Donald Trump, it is improbable that the Supreme Court would intervene. Judge Merchan's forthcoming sentencing decision is expected to be well-founded in law and unlikely to present such an issue. Therefore, the Supreme Court's involvement in this specific aspect of the case remains highly doubtful.
Could you clarify that the Supreme Court's decisions, regardless of the rationale they provide, ultimately must be accepted because there is no higher authority to rebuke or overturn their judgments?
You see, unless something extraordinary happens, like Donald Trump assuming the presidency again and deviating from the democratic norms to become a dictator, there isn't a higher authority than the Supreme Court in our legal system. Now, that might sound like a plot straight out of a Hollywood movie, but it's crucial to understand the implications here. If such a scenario were to unfold, where a president disregards Supreme Court rulings, we would find ourselves in what's termed as a constitutional crisis. When we talk about constitutional crises, it's not just about a president overstepping their authority or using power questionably. It's when the checks and balances built into our system, like the Supreme Court acting as the ultimate legal authority, are undermined or ignored. This isn't about normal political disagreements. It's about a fundamental breakdown in how our government is supposed to function. In such a crisis, there's no clear legal mechanism to resolve conflicts between branches of government. The Supreme Court is the last resort under our Constitution, and if its decisions are disregarded, there's no tiebreaker left. This leaves us in a precarious situation where the branch with the most military might could effectively dictate outcomes, bypassing the established legal framework.
Shifting topics a bit, there's a noticeable confidence from Donald Trump's legal team and supporters regarding their appeal prospects. From what you've seen, does this confidence seem grounded in reality, or is it more of a hopeful narrative spun by the Trump camp?
You know, it's funny but also quite serious when I hear Donald Trump's lawyers sounding confident about their chances on appeal. It reminds me of a classic scene from the movie Animal House, which I loved growing up. There's this moment where the dean tells Mr. Blutarsky that his grade point average is 0.0. Now, I don't want to turn this into a comedy routine, but that scene perfectly captures how I view Trump's odds on appeal, close to zero. It's not just wishful thinking or desperate optimism from Trump's camp. It's like they're trying to spin a narrative that's almost comically unrealistic. In legal terms, the chances of success on appeal for Trump are extremely low, akin to someone trying to argue that a 0.0 GPA is actually a good thing.
How lengthy is the appeals process anticipated to be, and perhaps more crucially, would it delay him serving his sentence? For instance, if he receives a prison sentence, as we'll discover on July 11th, would that sentence be postponed while he appeals?
It's a nuanced situation that hinges on several factors. Firstly, the prosecutors are likely to push for a prison sentence considering the gravity of Donald Trump's 34 felony convictions. Judge Moran will then weigh the evidence and arguments before making a decision on the sentencing. Now, if Judge Moran does indeed order a period of incarceration, there's the question of whether he might choose to suspend or delay that sentence pending an appeal. The option to suspend a sentence isn't commonly exercised, but recent events, such as Judge Carl Nichols' decision regarding Steve Bannon, show that exceptions can occur. This introduces an element of uncertainty regarding what Judge Moran might decide in Trump's case. If the sentence isn't suspended, Trump could pursue an appeal to the New York Appeals Court, seeking to halt or delay the implementation of his prison term. However, it's important to note that predicting the outcome of such legal maneuvers is challenging. These decisions often hinge on legal nuances, precedents, and the specifics of each case. So while there's a possibility of appealing and potentially suspending the sentence, the ultimate outcome remains uncertain until the legal processes unfold.
Sure, we'll be keeping a close eye on all developments as this legal process unfolds. If you're tuning in and want to stay updated on everything, from the sentencing to the appeals and beyond, be sure to hit that subscribe button to stay informed with the latest news.